early retired district judge. I took VRS in the month of February 2008. Thereafter, I did practice in Odisha High Court and Supreme Court. After 2 years, I completely left practice and involved myself in social services. I tried educating people in different places by holding meetings and writing in papers and Facebooks, social media, that people should be enlightened, people should know about their rights. Unless people know about their rights and duties, they cannot be good citizens of the country. I have been making program in this law and politics since last 1 month. Already we have finished 14 parts, and now I am going to part 15. With me, two brilliant anchors are there. Previously they had anchored with me Srushti, sitting to my right, Srushti Mahapatra. She anchored part 7. This is Suchintita Das. She had anchored part 5 and 6. Now they will ask me questions and I will give answer. We are doing this part in English because many people requested to make it in English so that it will be known by many people. Accordingly, we are doing this program. Now I permit them to ask me question. Srushti.
Good morning, all of you. I'm Srushti Mahapatra. I'm going to ask sir some questions about today's issues that I'm going to address. So, my first question will be, sir, will you kindly say some rights and duties of a human being?
Yes, a man has got two types of rights and duties. One is moral right and duty. The other is legal right and duty. We are concerned with legal right and duties. Moral rights and duties, one may do, one may not do. There is no problem for that. But if one does not comply legal rights and duties, then one may be punished. So we are concerned with legal rights and duties.
Sir, please narrate the legal rights and duties of a man.
You say many jurists like Gray, Holland, Austin and Salmon, etc. have defined right in a very lengthy way. We are doing this program for understanding of common people. So I will give a shortcut definition of the same. Right means everything that one can do which is not prohibited by law. Duty means which has been prescribed, which has been directed by law to be done. So right is an interest, duty is interest should be respected by all. If all break the interest, then that is wrong. So in this way we should understand what is right, what is duty and what is wrong.
Good morning everyone, I am Suchintita Das and I am here to ask Sir some legal contemporary questions. And my first question is, Sir, can a person plead on his own behalf?
Yes. A man can plead his own case. This is a right. Nowhere. That means nowhere in the law it is prohibited that one cannot plead his own case. I have already stated which is not prohibited, that is his right. So when it is not prohibited, it is your right. One can very well plead. Many people pleaded before me while I was doing as a judge. Even I remember about hundreds of people have pleaded their own case and they have also pleaded very successfully.
Sir, my next question to you is, can anyone speak in his case personally even though he has appointed an advocate in the case?
Yes. If a man has, suppose for example, if a man has engaged 2 to 3 lawyers, then each lawyer is also addressing to the court. So in the similar way, if a man has engaged an advocate, he can also speak to the court. There is no prohibition for that. Only thing is that common men are not experienced. They do not know what question should be put, what is relevant, what is irrelevant. They may damage the case. For that they are not allowed. But there is no prohibition for that. During my tenure of service, I have permitted many people to speak in presence of their lawyer. That is the law. We should not prohibit them. We should understand, we should claim that right. If the lawyer is, the other side lawyer is prohibiting, protesting, we must bring the knowledge, bring to the knowledge of the judge and seek protection from him, and we should plead our own case. Okay.
Sir, my question is, a person filed a criminal case against an accused and lost the case. can that person file a civil case against the accused for the same incident?
Yes, very much he can file. Losing a criminal case does not mean that he is prohibited from filing a civil case. Many people wrongly say that it is double jeopardy. I will explain what do you mean by jeopardy. Jeopardy means punishment in a criminal case. So, if a criminal case was done and thereafter a civil case is being done, question of a double jeopardy does not arise. Suppose a man is punished or acquitted in criminal case, then a civil case went on, then also a departmental case can go on. Nobody is interfering with no case is interfering with the other case. Question of a double jeopardy does not arise. Okay, yes, one
Sir,
can do.
my next question is, the accused was released on bail in a case. Neither the accused nor his advocate, if any, appeared in the case on the date fixed by the court. What would be the consequences of the accused?
You say previously when accused was released on bail, if he was not coming, the court was very much particular to catch the bailer. Court was casting all duty on the bailer to bring and produce the accused. So accused were after going concealing themselves absconding. Law has been amended in 229 IPC, 29A IPC, provision has been made if the accused absconds, does not come to court after being released on bail, nor is the lawyer takes steps on his behalf, then he shall be punished. He can be sentenced to jail up to 2 years. So everybody should know that after getting bail, you are not free, you are duty bound to attend court date wise.
Sir, my question to you is, can you start a case in the court by complaining orally or by presenting an application or by sending letters, emails, fax, etc.? Kindly explain.
Yes, very much you can do. In a criminal case, all the above methods are possible. But in civil case, the provision is you must file a written application which is known as a plaint in the court itself. You must present it, or your lawyer or your agent will present it. If you write letters or go and speak orally something in civil matters, court will not take cognizance of it. One thing nowadays court can do, if you write some civil matter, court may send it to legal aid scheme for giving redressal to you.
Sir, my next question to you is, by your answer it is revealed that prosecuting a civil case is quite cumbersome and difficult. So kindly explain how a poor or an illiterate person can file a civil case.
A poor man, illiterate man, ladies, children, so SC, ST people, etc. can apply to district legal aid center, district judge for getting help, wherefrom they will get necessary help and they can contest their matter. Their right will not be affected, their right will be protected. It is a constitutional right of every people and it has been enshrined in Legal Authorities Act, whereby we will get facility, poor people get facility to contest their own cases.
Sir, please tell us whether after selling the land or making a gift of it after that, is it an offence? If yes, is there any punishment for such an act?
Yes, yes. After selling the land or making a gift of it, if a man further sells it, resells it, or makes further gift, then he will be punished. It is cheating. So now we find many people are selling the land time and again. Those who have purchased the land later, they are only coming to get back their money. They are just smashing their heads by crying what they can do. They never go for filing criminal cases. If they file criminal cases, then those people will be punished and it will send a good message in the society. So nobody will venture to resell or to make a further gift of the land after selling it.
Sir, now I will ask some questions concerning the witness of a case.
Yes, you can ask, very much you can ask, you are welcome.
Sir, my first question is, if some person avoids to receive summons or after receiving summons doesn't attend the court, then what would happen to that person?
Yes, it is punishable under section 172, 173 and 174 of IPC. In such a case, he can be sent to jail and also fine can be realized from him. So, the persons who are getting witness summons from court should come to court. They should not avoid, they should not conceal themselves They should, if they hide themselves, then if it is reported to court, they will be punished. So everybody should be very much aware of this legal provision.
Sir, my second question is whether court can compel any person to produce his document in the court?
Yes, court has absolute right, very much powerful right court has got. Court can direct everybody, anybody to produce his document under section 165 of the Evidence Act. But there is an exception. In civil cases, if a man is not party in the case, then he cannot be compelled to produce his title deed relating to the document. If he agrees in writing before the court that he is ready and willing to produce the document, then only court can compel him to bring the document, or else court cannot simply send a notice to or someone to him to produce that document. If a court by mistake sends, then the man should come to court and explain the situation, the position of law enshrined in section 130 of the Evidence Act, that he is not liable to produce the document.
Sir, the next question is whether witness is bound to answer to court's question. If the witness fails to answer, whether court can compel him to answer.
Yes, when court puts question, the witness is bound to give answer. Now supposing if he gives answer, then he may be liable in any criminal matter, or his property may be somehow lost. Still then, he will be bound to give answer under section 132 of the Evidence Act. The only precaution, the only privilege for that person is that whatever he has answered, being compelled by court, those answers will not be utilized against him to book in a criminal case or to produce or to use in civil cases. So everybody should give answer to court, even if it goes there. An example, suppose A is becoming a witness in a court and is stating something. Now the court asked, did you take part in the assault? If you answer yes, then you would be liable. But under section 132, you will not be liable because your answer will not be utilized against you. So you need not shirk, you should answer.
Sir, whether court can ask irrelevant questions to a witness?
No, neither court nor lawyer can ask. Yes, court can ask, only court can ask irrelevant question to the witness under section 165 of CRPC, though the answer will not be utilized in judgment, but the witness cannot say, sir, why are you asking irrelevant question? Court has got such a right.
Sir, whether an advocate or court can ask insulting questions to a witness?
No, neither court nor lawyer can ask any witness unreasonable questions, scandalous questions, annoying or insulting question to him. It is prohibited in the law. So I have told what are prohibited in law should not be asked. These are prohibited in law. So court and lawyers are careful. They never ask it. If a lawyer by chance asks, you bring the attention of the court, draw the attention of the court, court will prohibit the lawyer from asking such questions.
Sir, our next question to you is whether in order to know the progress of one's case, can one ask the court about the same?
Yes, if the man is present in the court, he can very much draw the attention of the court. There is no problem. Nobody should fear to the court. Court is ready, court is sitting openly to listen to the problem of people. The only thing is you should be very careful. If you find the court is in work, then you should wait. If you still find that court is not taking note of you, then you give a chit to the pescar. The pescar bench clerk. The bench clerk will bring the knowledge, bring it to the knowledge of the court, and you can talk with the court. No problem. These are law, your right. You should understand. Why do you fear? No fear. This is your right. I have already told what is your right. Please understand your right. You can ask.
Sir, my next question to you is, when a victim of an occurrence does not start any case, then can in that situation any other person can start a case?
Yes, in criminal matters, not only the victim, but anybody from the society can start a case. Supposing A is assaulted, he is not starting any case. C or D, anybody if he knew, they can file a case. Even if it comes to the knowledge of police, police can also start a case. Supposing somebody wrote this matter to court, court got letter, court also can start. So criminal case can be started by the victim and by others, including police and court. But in civil matters, only the victim will start the case. If the victim is incompetent due to minority or insanity, then their guardians will file the case. If the guardians do not come forward, then there is provision to approach the court. Somebody must represent, somebody must be guardian for the minors, and in this way civil case can be started directly. No minor can start a civil case.
Sir, whether keeping sexual relationship with a girl below 18 years of age, even if such girl is the wife of that person, would that thing would amount to any offence?
You say in Indian Penal Code the offence of rape has been defined. There it is stated if the wife is above 16 years of age, then that may not amount to rape. Now such matter went to Supreme Court by an NGO known as Independent Thought. The NGO is known as Independent Thought. It filed a case against the Union of India. That case was decided by Honorable Supreme Court in a writ petition case number 382/2013. Supreme Court decided on 11/10/2017 that even if the girl is your wife, if she is less than 18 years, keeping physical link with her will amount to rape. So everybody should be very, very careful that if the girl is below 18 years, don't utilize them physically or mentally, even if they are willing. That is not a matter of excuse. Now it will amount to rape. That is the law of our country.
Sir, whether one can write a letter to the court about his grievances?
Yes, one can write a letter to the court. I have already told if it is a criminal matter, court will take cognizance of it. But if it is a civil matter, court will not take any cognizance of it. Court will simply file it, or if court likes, court can send it to legal aid. Legal aid scheme is there. They will call you and they will finalize your matter.
We hope this session was full of expertise and cognition. Thank you, sir, for enlightening all of us by addressing the legal and contemporary issues.
If you have not subscribed the channel yet, please subscribe it. And if you have subscribed it, thank you so much. Thank you for all your warm comments. We all read it, and we get encouraged when you put comments. And thank you for cooperating us. And press the bell icon also if you want to get the notification of our video. We are ending the session here. Thank you so much.
Thank you.